Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Welcome to the Appeals Court. I am Justice Meade. With me today are Justice Sullivan and Justice Sachs will be the panel for your case. We're going to do our very best to hope this goes off without a hitch. If we run into any technical problems, we'll reestablish our connection and no one will lose any time that they've been allotted. With that, I'll call our first case is 2019 P19 Commonwealth versus DAVOREN. Ms. LeClaire.
Thank you. May it please the court, Jessica LeClaire for Joshua DAVOREN. The first issue I want to address is the facial validity of Section 269, Section 10H1. And I want to first point out a slight error in the Commonwealth's brief. They say on page 22, this issue was not raised below. I did concede that this issue was reviewed for a substantial risk of a miscarriage of justice because the facial validity wasn't raised in a motion to dismiss pre-trial. However, it was discussed at a motion for required finding. And Section 10H1 is facially invalid because it categorically bans the exercise of the very core Second Amendment right. It has two elements: the knowing possession of the shotgun. That's all the Commonwealth has to prove to support a conviction. And for that reason, all possession is unlawful, categorically unlawful. It doesn't matter if you're in your home, if you're a law-abiding citizen, or it doesn't even matter if you have an FID card. An FID card does not confer the Second Amendment right. It confers only the very watered-down right to raise an affirmative defense if someone is prosecuted.
But we're talking about whether the statute has a plainly legitimate sweep here, right, on a facial challenge?
Well, because this is what Heller and McDonald have said is that because this law, a law that burdens the exercise of the Second Amendment right is subject to heightened scrutiny. And so this law, because it burdens the core Second Amendment right, is subject to strict scrutiny.
Sure, but on a facial challenge, if the law has a plainly legitimate sweep, then it's not facially unconstitutional. Would you agree with that?
Yeah, I agree that that is the standard.
So if unless it appears that even those people who have FID cards are being convicted of unlawful possession, or that their defenses of having FID cards are being regularly rejected at trial, then why doesn't this law have a plainly legitimate sweep?
Because let's take the person who has an FID card. That person is still subject to prosecution. In order to defend themselves, they have to sacrifice their 14th Amendment right to have the Commonwealth prove the act was unlawful. They also have to potentially give up their Fifth Amendment privilege against self-incrimination. The jury is free to reject that.
Producing an FID card?
I'm sorry, Your Honor?
They give up a Fifth Amendment privilege by producing an FID card?
The prosecutor, the law enforcement still has the right to prosecute that individual. And what we see is, if you draw an analogy.
But unless that's being regularly exercised, doesn't this have a plainly legitimate sweep? I mean, you're pointing to a theoretical, what appears to be a theoretical possibility of, in some cases, people's First or Second Amendment rights being burdened even though they have FID cards, but there's no indication that that's happening. Why should we strike down, even assuming we can do so? I'm not seeing where there's no plainly legitimate sweep.
Oh, so there are two answers to that. The first is that because anyone can be prosecuted, even someone with an FID card, this gives the government, law enforcement, absolute total discretion over who to prosecute. The fact that they have chosen not to prosecute is a matter of prosecutorial discretion. And so that opens the door to selective enforcement. And we see that in the context of the gun laws. We see that over 70% of mandatory firearm offenses, over 70% of those convicted are Black or Hispanic. So you're seeing staggering disparity in enforcement of the gun laws against people of color. The second reason, though, is because the underlying statute that confers the FID card is itself invalid. What Heller and McDonald said is that, again, you have to have strict scrutiny when the law burdens the core Second Amendment right. Well, they said heightened scrutiny, they didn't specify. And the police have discretion to deny an FID card to anyone for any rational reason under, and the defendant—
Like if they were convicted of felonies, right?
I'm sorry, Your Honor?
As if one rational reason to deny an FID card if someone has a criminal history involving felonies.
That's true, but the government isn't required in a prosecution which subjects a defendant to the loss of liberty for exercising that constitutionally protected conduct. The government doesn't have to prove that individual was a felony. So that might be a rational reason to deny. That would be might be a compelling reason. That hasn't been litigated, whether or not felons can be deprived entirely of
Are you telling us that the Second Amendment is absolute and in no way can be regulated by the government?
No, I'm not saying that. I'm saying that this statute itself, the reason it's facially invalid is because it doesn't require the government to prove that the person who exercised that core right was ineligible to exercise it.
They did that in this case.
In this case, they proved a lack of an FID card, but that's not an element of the statute.
I agree. It's
right,
an affirmative defense.
Right. So the SJC has said they only have to prove these two elements, and they did prove that, but they didn't prove lack of it, that this person there was a compelling reason why this person was ineligible. So if the law required proof of that, it would be constitutional.
Do we have to overrule Powell, which we can't do, in order to rule in your favor on the facial challenge?
It's a good question. Because I've applied for direct appellate review on grounds that this court can't overrule the SJC. This case does present a slightly different issue in that this defendant was convicted for having a shotgun in his home, and I did challenge whether or not he was entitled. What the SJC has said is these claims are unreviewable on appeal if you don't demonstrate that you tried to get a license, and that's not something that was done in this case. So the short answer is I'm not sure. It's I think
seems tough.
Yeah.
I mean, that goes to the as applied challenge, right?
Yes, that does go to the yes.
I want to make sure and get to at some point to your challenge to the sufficiency of the evidence on the ACC issues.
Yes. Sure. Okay.
Would you agree if the ADA had testified? I'm talking about the assault and battery on the defendant's mother charge.
Okay.
If the ADA had testified in the second phase of the trial here, I stood up in court, I recited the facts, including, and let's just say, including that the defendant punched his mother in the nose. And I heard the judge ask the defendant if he agreed with that, and the defendant said he did. Would that be sufficient for the jury to find that this was a violent felony?
It's a tough question because I think that the point is that the point I'm making in my motion is that the purpose of this hearing is not to reconstruct the plea colloquy. If the ADA
I'm asking if that is evidence. If in essence the ADA got up and testified, I heard the defendant admit that he punched his mother in the nose. Is that sufficient evidence that he committed a violent felony, a harmful A and B?
It would be I think the answer is no, and that's because the ADA would have to say, I'm charging you with an intentional harmful battery, and you're admitting to an intentional harmful battery, and
Why?
the
If
element.
the facts, I mean, isn't the ADA reciting facts that leave no doubt that it's a harmful battery? He punched his mother in the nose. That's not an offensive battery. I mean, it might be offensive, but it's also harmful.
Because the defendant is having a conversation with his attorney, and we don't know whether the attorney is saying, you know, we realize that you didn't punch her, you didn't think you were causing any harm, but this was certainly an assault and battery one way or the other. And so a defendant has to know the elements he's pleading guilty to.
But if the ADA says, I expect to prove at trial that he punched his mother in the nose, and the judge says, defendant, do you agree with that, Mr. DAVOREN? And Mr. DAVOREN says, yes, I do. Why isn't that an admission that is sufficient to find beyond a reasonable doubt that he punched his mother in the nose?
Well, it would be, it's sufficient to prove, it would be sufficient to prove an intentional battery at the plea on the assault and battery. But the point that I'm trying to make is that the ADA is not supposed to be testifying at this 10G hearing. What the SJC said in Commonwealth v. Wentworth and Rivera v. Commonwealth is they have to prove the defendant's conduct as it was committed.
Yeah, but why can't you prove the defendant's conduct by having the defendant admit to his conduct in front of the jury that's hearing the evidence in this ACC trial?
In front of the jury.
I'm sorry, by hearing evidence that the defendant, the jury in this trial would be hearing evidence that the defendant admitted to, in my hypothetical, punching his mother in the nose. Why isn't that sufficient? I'm not saying that's what happened here, but I'm just trying to test your position. Why wouldn't that be sufficient?
Because the reason that, well, I think that, yeah, I think it might be, it depends on who's testifying to that. So is there a transcript, an admissible transcript? Because an ADA is not a competent witness because an ADA was not present at that occasion.
No, the ADA who was at the plea colloquy, it was a former ADA Lux who testified in this case. She was at the plea colloquy on the A and B on the mother, and she testified as to what happened there.
Right. Well,
why isn't she competent to do that?
Because the purpose of the of this 10G hearing is not to prove what he admitted at the prior plea. That's not what the Commonwealth.
It's to prove what he did. And one way of proving that is by proving what he admitted to.
If I may, I'd like to read you a sentence from Commonwealth versus Wentworth. It's at page 677. As the SJC closes out its analysis of this issue, it says, quote, here the facts to which the defendant pleaded guilty involved a violent, harmful battery sufficient to satisfy the force clause. Why does that sentence not tell us that evidence of what the defendant admitted to by pleading is sufficient? I'm rephrasing Justice Sachs's question, essentially.
So that was actually my case, and what the defendant admitted to, he admitted to at the ACCA trial. So when he pled guilty, that phrase refers to him pleading guilty to being an armed career criminal under the ACCA, not to what he pleaded to in the earlier plea proceeding. And so, I mean, you know, in the sense that would that testimony be, is it sufficient? I guess the answer is yes. If hearsay, if multi-level hearsay comes into the courtroom, into the evidence, and it's admitted for its full substantive value, then yes, that testimony that he punched his mother in the nose is sufficient, would be hypothetically sufficient. But that evidence is, what our argument is that evidence is incompetent because you have to have a percipient witness. It's
but what's the difference whether he pleads in the ACCA hearing or he pleads in the underlying felony? I understand the posture in Wentworth was different, but what's the functional difference?
Because let's take a defendant who pleads to an assault and battery, but he's charged with assault, battery, dangerous weapon, but he pleads to an assault and battery. He pleads guilty. At that plea hearing, the government recites facts consistent with an assault, battery, dangerous weapon. The defendant isn't tendering a knowing involuntary plea in that prior proceeding to assault, battery, dangerous weapon.
That's a different argument, though. Whether it's knowing involuntary is different than whether it's competent.
Right. And I mean, we're arguing, but I mean, I raised both issues, right? But in this case, Attorney Lux actually says, I don't know which version of A and B he was pleading to. So she says she doesn't know which one of those he pled guilty to. But again, I think this points out what the bigger issue in terms of the 10G trial is that the defendant is entitled to have a trial. And this proceeding was more similar to more of a Rule 30B motion for required, where a defendant seeks to withdraw his plea and there's no colloquy, there's no transcript of the colloquy. And in that situation,
we're gonna have to, I think we understand. Your time is up. We're gonna have to leave it there.
Thank you, Your Honors.
Ms. Lynch. Kristen, can you unmute Attorney Lynch?
Sorry, I got it. I was looking for my mouse. I apologize. Good morning. May it please the court, Assistant District Attorney Bethany Lynch for the Commonwealth. And with the court's permission, I will briefly discuss the facial challenge issue, and then I will shift to the violent crime under the ACC. For the facial challenge, there are two ways that you can make a facial challenge. The burden's on the defendant to show that the statute either lacks a plainly legitimate sweep, or there's no way that the defendant can comply with the statute and exercise his constitutional right to bear arms in this case. And clearly there is a plainly legitimate sweep. There's a public safety issue for keeping firearms from felons and mentally ill.
I'm sorry to interrupt. Ms. LeClaire told us that this was preserved at trial.
It was not preserved pre-trial in a motion to dismiss. It wasn't raised in any great detail. It may have been put in the required finding, that I just do not recall.
Can you preserve a facial challenge in a required finding?
I would not believe so. And I think that this is a substantial risk of a miscarriage of justice standard. I believe that the defendant agrees with that the standard of review here is substantial risk. And in this case, the defendant, this statute, it's been held in multiple cases in Police Chief versus Holden, in Powell, in Lodeholt. All of these cases have found that the legislative statutory structure that requires that a person who seeks to possess a firearm within their house get an FID card does pass constitutional muster. And then, very briefly, the defendant in this case did not apply for an FID card. There's no evidence that he applied for an FID card, and this wasn't raised in a motion for new trial or in the 25B2 motion, so we don't have any real evidence as part of the trial record. But we do know, based on the defendant's criminal record, which was part of the search warrant, that he would not have been eligible for an FID card as well had he applied. So his as-applied challenge is also not properly before this court, because in failing to apply, he's not now entitled to challenge the statute as it applies to him. As for moving on, unless there are any questions on that, I'll move on to the ACCA challenge. In this case, the defendant sought post-conviction. Well, he raised it in the motion for required finding, and the judge had him put it into a 25B2 motion. And he raised the issue of I'm going to call it the Mathis issue. He sought to have this judge use the categorical approach as applied to all of the charges against him. And
we understand that doesn't cover it.
It's the modified categorical approach is what the court
So adopting that approach, how did the prosecutor prove at the ACC trial that the A and B on the mother was a harmful battery rather than an offensive battery?
Well, she testified, I believe she testified, she and it wasn't just her, it was also the arresting officer who testified as to the facts. So the Commonwealth wasn't required to just use the prosecutor.
Well, but all the prosecutor could testify to is what she expected to prove at trial.
Exactly, yes,
Right.
and she
So
did
she
testify.
did do that, but she doesn't testify that the judge asked the defendant if he agreed with that and that the defendant said yes.
Well, I think that you can infer that that happened only because otherwise the plea would not have been a successful plea.
But that's not before the jury what the requisites of a successful plea are, and we don't see judges always asking defendants, "Did you agree with that statement?"
Well, I think that in this case, the Commonwealth is not required to reprove the facts of the underlying case beyond a reasonable doubt in terms of bringing in precipient witnesses.
No, but it's got to prove what kind of A and B it was.
We do, and I think that between the prosecutor putting forth what she would have told the judge about the facts of the underlying case and what the officer reported the facts of the underlying case, there was no evidence at all that it was limited to an offensive touching. All of the facts of this case had to do with a violent attack on his mother. So the fact that he didn't affirmatively adopt that, he did plead guilty to that. And he pled guilty to the facts as presented.
He never said, I mean, according to former ADA Lux, the defendant was never asked to whether he agreed with her recitation of what she expected to prove. He never agreed with that. And she said she didn't know what elements of A and B or what type of A and B he was pleading to. That's what she testified to at the ACC trial.
I think you have to look at what the facts were, though, because there really was no theory of assault and battery in this case that the defendant could have pled guilty to that was a nonviolent felony.
How do we know what the facts really were? All we know is what the prosecutor said she expected to be able to prove at trial. Now, if the defendant had said, if the judge had said to Mr. DAVOREN, do you agree with the prosecutor that that's how it happened? And Mr. DAVOREN had said, yes, I do, then that would be an admission. And I think you'd have sufficient evidence. But where that didn't happen, I'm not seeing how the Commonwealth proved what the facts of the A and B were.
Again, I would just say that it's an inference to be drawn from the testimony of both the officer as to what the facts were reported, and then also the prosecutor reporting what she would have presented to the court as part of the plea, and the fact that he did plead guilty to assault and battery. And I think it's not reasonable to need that extra admission, that one more question, that extra admission by the defendant in this situation in order to make that inference that he's because I don't think it's reasonable to assume that he's pleading guilty to facts that were not presented in court. The officer testified as to what the facts were, that of the purpose of the arrest or the basis of the arrest, and it was the attack on his mother, the violent taking of the phone and all of those things, pushing her to the floor and choking her. Those were the things that the officer, that's why he was arrested. And then the prosecutor said that she presented those facts, or she expected to be able to prove those facts. And then the defendant pled guilty. So to presume that he pled guilty to some other version of the facts that somehow removes all elements of violence from this is, I would suggest, not as reasonable an inference as the inference that he pled guilty to the facts that were presented. And in order for this to be a nonviolent felony and thus not qualify under 10G, it would have to be an offensive touching, which is a very minimal touching, it's a tickle, a poke, something like that. There's no way to read the facts of this case, as the officer testified, that that would possibly reduce it to that theory.
Well,
And eliminate the violent, the harmful, or the offensive the harmful or the reckless battery.
okay, so at least what the prosecutor testifies to, former ADA Lux, Mr. DAVOREN went after his mother. She was forced to the floor. He took the phone away from her as she was attempting to make the phone call. He had put his hands on her. She ended up on the ground. He put his body over her, attempted to grab her throat, but then stopped. Then grabbed the phone out of her hand and took it from her. Is that a violent A and B?
Yes. Yes. That's a violent A and B. That's a harmful or a reckless touching, because he's on top of his mother. He's not just poking her or tickling her or something like that. He is knocking his mother to the ground and getting on top of her and nearly choking her. And so,
Where does it say he knocked her to the ground?
I'm not sure if the prosecutor said that or if it was the police officer. I believe that he pushed her and she fell to the ground. He put his hands on her, and perhaps I'm making an inference that when he put his hands on her and she ended up on the ground, that the two things were related. But she ends up on the ground and he's on top of her trying to, and so how that is merely an offensive battery, or how a jury could conclude that. And I would suggest that the jury could, I suppose they could conclude that, but in terms of sufficiency, that evidence was enough, that plus the fact that the defendant pled guilty was enough for sufficiency purposes for a required finding in the light most favorable to the Commonwealth, to show that the Commonwealth adduced sufficient evidence of a violent felony or a theory of violent felony on the assault and battery on his mother.
And you think, and you're basing that, I think you have to base it on the prosecutor's statement alone, because as I'm looking at the testimony of the police officer who was involved, he gives no details that I can see of the of the assault.
Yes, yes. I'm sorry, I'm just quickly looking. Yes.
So where the ADA says she doesn't know what elements of A and B or what type of A and B he was pleading to, it's still sufficient for this jury in the ACC trial to find beyond a reasonable doubt that this was a harmful battery, not.
Yes, based on those facts. I don't, because the prosecutor maybe doesn't know in her mind what theory he was pleading to, I don't see how those facts could be an offensive battery alone, and not also be, even if it is an offensive battery, how it is not also a harmful or a reckless battery, which qualifies as a violent felony.
Did the judge instruct this jury on the elements of the crime?
He did. At the defendant's request, he instructed.
So that's how they would know.
Yes.
Can I ask a different question?
Absolutely.
On the business records issue with the Firearms Record Bureau, the SJC has said that the Commonwealth does not have to prove that he doesn't have an FID card, right?
That's correct.
So why did you put this stuff in?
That I can't answer.
Okay.
That I can't answer. Yeah, I think it was sort of a belt and suspenders. I think he was trying to kind of head off an issue that shouldn't even be an issue, and then sort of created one. So
It's like proving lack of insurance.
exactly. If the court has no other questions on any of the issues in the brief, then the Commonwealth would rest on its brief and ask that the convictions be affirmed.
Seeing none, we'll take this under advisement. Thank you both.
Thank you.
And we're live.
Okay, welcome to the Appeals Court. The panel today is myself, Justice Meade, Justice Sullivan, and Justice Sachs. So we'll be hearing your case. If we run into any technical problems, we'll do our best to reestablish any connection that is lost, and no one will be deprived of the time. With that, I'll call the next case is 2019 P 705 Commonwealth versus JENSEN. Mr. Benyon.
To the presiding justice, and may it please the bench. I raised, and my client wishes to raise, two issues with this court concerning his trial. The first is a sufficiency argument. And this court will review the evidence as it relates to self-defense. Your review is to determine whether any rational trier of fact could have found that the Commonwealth proved beyond a reasonable doubt that the defendant did not act in self-defense. You may not have had a chance to read the transcripts yet, but I have no doubt that you will read the transcripts before this determination is made. I just want to point out with respect to the first argument, a few points. Take particular attention to Mrs. Gaynor's testimony. The Commonwealth presented the interaction as between my client and the four people as my client acting irrationally and the group of four acting rationally and calmly, whereas if you pay attention to Mrs. Gaynor's testimony, she's the witness who was driving by with her window rolled up. She was able to hear them specifically, not just my client, but that she heard a lot of yelling. And also my client wants you to pay particular attention to his testimony. He feels that the government did not prove that he did not act in self-defense.
But you'll agree, Mr. Benyon, that we have to view the evidence in the light most favorable to the Commonwealth, though.
You do, but again, this court's review is to make sure that that the lower court's determination was proper, that justice was done, and it complied with not only the standards of review but the evidentiary rules. And so that's what my client's asking this court to do. He feels that given his testimony, the Commonwealth didn't prove its burden. And while this court could just say that it was up to the jury to make a credibility determination, that is the argument that leads me into the second of my arguments. And I don't know if you have any questions about the first argument. It's fairly simple and straightforward.
The Commonwealth's witnesses said that the defendant made no attempt to avoid the confrontation, and that he didn't walk away, he didn't try to get away, and no one stopped him from getting away.
So again, my client's version of events are different, and you'll read.
I know, but back to our standard though. The jury was entitled not to credit the defendant's testimony.
That's true, but the way the government presented their case placed a significant burden on my client with respect to credibility, and that's the second argument that I want to make. Should I go forward with the second?
Go ahead.
Does anybody in the panel have any questions as to the first argument? It's fairly straightforward. Again, it's a straightforward sufficiency argument. What I do want to talk to you about, and I hope you take seriously, is that once again, this court is being asked to consider the use of bad act evidence in a case. This court always recognizes the prejudice that comes from this type of bad act evidence, but it never seems to find it in the case before it. My concern is that the exceptions to this exclusion of bad act evidence rule are so broad that the exceptions swallow up the rule, and it really is nothing but a dead letter today. There are times where the government should be able to bring in bad act evidence. I recognize that, but this is one case where I can't see for the life of me why the government did this, except to prejudice my client, his credibility, and that's the problem. So the way this occurred, and the trial counsel brought in a motion to try to keep this out, but it was allowed in, and it was with respect to Mrs. De Silva. This is the witness who, during the event, was in her apartment and she heard the events. She later contacted the police, and she testified at trial. But one of the things that was brought up to the jury was the fact that she felt that my client had intimidated her because she was a witness. Now, I've included in my brief portions of her testimony. It seems fairly benign to me, but if the Commonwealth wanted to bring this evidence in, they could have done so by charging him, which they did, but making it in connection with this case. In other words,
Are they required to do that?
they're not required to do that. But again, the underlying problem here is that the government gets to put this evidence on. And number one, the government never informed the jury what the standard was for witness intimidation. They never informed them that they had to find that he intimidated her beyond a reasonable doubt. In fact,
but the jury wouldn't have to find witness intimidation beyond a reasonable doubt. There are lots of kinds of consciousness of guilt evidence that don't involve commission of crimes. And
I understand
those don't have to be proven beyond a reasonable doubt. The jury has to find, essentially by a preponderance, that that these acts occurred, and they were instructed. If you find that these acts occurred, then you can consider them as consciousness of guilt. But there are many reasons why people could do things, and it doesn't always indicate consciousness of guilt.
Again, but when the government brings in, again, this evidence is problematic because it's inherently prejudicial, right? My client comes in, he has a disagreement with respect to what the facts are. This is a fact-heavy determination by the jury, dependent upon the credibility of the witnesses, and the government brings in this non-connected act. When the government...
Isn't it up to the jury to decide whether it's connected? And the fact that it's prejudicial because it makes it look as if your client is conscious of his guilt is something that for the jury to determine. The question is it unfairly prejudicial?
It is unfairly prejudicial. It's not relevant to this case that the defendant sat on his own front stoop and said nothing to his neighbor when she came out, but she still felt intimidated.
Well, he did it 3 days in a row, and she'd never seen him there before. And the first day he sat there, and the second day he stood in her way and she had to walk around him, and the third day he stared at her for a while and then laughed at her.
Again,
why couldn't the jury, if it believed that evidence, decide that he was trying to intimidate her?
Because bringing in the bad act evidence, again, is inherently prejudicial. The exception can't be made to swallow up the rule that that the jury then gets to look at him in a different light. In other words, they're viewing him not only as somebody who engaged with the four people who were out walking, and the question of whether he acted in self-defense is the main point, but the Commonwealth brings in this separate point that my client feels is completely unconnected and unreasonable. When the government brings in this type of prejudicial information, and it's not even information, it's a theory that the government has that he intimidated her. I mean, this really could have just all been in her own mind.
I don't think it was a big part of the Commonwealth's case, though. I mean, the prosecutor doesn't even mention it in closing argument.
Again, the damage is done once you put the witness on the stand and have this woman testify that she felt intimidated, whether he was truly intimidating her or not. That should be the main thrust of whether he was intimidating the witness or not. But in the context of this case, it's just this side circus that just lets the jury view him in a poor light. And the main issue is his credibility. That's the main issue in the case. He says it's self-defense. The government says it's not. It is going to come down to credibility. My client testified. And it's a distraction for the jury.
When he testified, was he asked about his interactions with Mrs. De Silva on those 3 mornings?
I believe he was. He did get to testify, and that's fine. But the point is that he's now not only fighting the accusation from the government, but he's fighting an accusation from one of the government's witnesses, and that's the problem. with this type of information coming in.
Do you really say that the jury ran amok when they acquitted him of 3 out of 4 charges?
I'm not saying that the jury ran amok.
Or was prejudiced?
Again, because it comes down to the credibility of the witness. A trial, again, doesn't need to be perfect, but it needs to be free from this type of prejudice where a jury can be influenced by this type of non-connected event. And that's the way my client views it. This had nothing to do with this case. It occurred afterwards, when he was on his stoop. And again, the jury is just kind of given information that is allowing them to view the defendant in a negative context. And when you have a case where a claim of self-defense is made and it comes down to the credibility of the witnesses, this is the type of case where prejudice matters for the jury. I understand that the jury acquitted him of certain things, but that could just be because they were following the judge's instruction, and that they just didn't see there was any reason to go forward with those. But as to the self-defense claim, a view of the defendant in that type of negative context can be very damaging. And that's why the cases talk about this type of prejudice and that it's not good. But as I view cases, it seems again that the exceptions to this rule have swallowed up the rule. They have eclipsed it. And it almost seems like it's just standard for the government to bring in this type of evidence. It's not connected. The issue in this case was self-defense and whether a battery occurred. That's it. If the government wanted to bring in witness intimidation, that's fine. It can make it part of their case. But to bring it in as just a bad act in the context of whether he had consciousness of guilt was improper. And that's what we're hoping that this court, reviewing all of the transcripts and motions that were filed, will see it that way, particularly paying close attention to those cases that I cite in my brief that talk about the prejudice of this type of evidence coming in before a jury. Sorry about that. Are there any questions for me with respect to the arguments?
Seeing none, we thank you.
I'll rest on the brief.
Mr. Lynch.
Good morning. May it please the court, Travis Lynch, Assistant District Attorney for the Commonwealth. With respect to the self-defense claim, the defendant's sufficiency argument is really nothing other than an attack upon the credibility of the Commonwealth's witnesses. In light most favorable to the Commonwealth, the defendant did not act in lawful self-defense. I would point to cases like Fluker and McCann, where the SJC has said, where the jury is properly instructed on the issue of self-defense, it's up to them to determine as a factual matter whether they believe that the defendant did or did not act in lawful self-defense. I believe that's really all there is to be said on the sufficiency claim. Unless there's further questions about that, I would move on to the other bad acts evidence briefly. And the judge did give a consciousness of guilt instruction with respect to this other bad acts evidence. I believe that the case law is quite clear that other bad acts evidence, even when it is a uncharged criminal act, is admissible. And as demonstrated by the jury's verdict, this other bad acts evidence did not make a difference in their determination. I believe someone mentioned earlier that the prosecutor did not mention this incident at all in her closing. I do not believe that the defendant was asked about it on cross-examination. I would point out, I included the judge's memorandum with respect to several of the pretrial motions. The judge did exclude a separate act of witness intimidation that the Commonwealth sought to introduce against a person named Duarte, who didn't end up testifying at trial. And then I would also point out that the Commonwealth also sought to impeach the defendant with a prior conviction for witness intimidation, which the Commonwealth was not allowed to introduce to impeach him. So combined with the fact that the jury acquitted of mayhem, the most serious count, it's very difficult to see what difference, if any, this allegedly improperly admitted other bad acts evidence made in this case.
Should it concern us that when the evidence was admitted, the judge didn't give the typical bad acts limiting instruction?
I don't believe so, because I don't believe there was an objection, and I don't believe that the defendant grounds his argument upon the absence of such a limiting instruction. And again, they acquitted of mayhem. So it seems though the jury apparently did not find beyond reasonable doubt that the defendant had malice. So no, I would say no. And unless there are any additional questions, the Commonwealth would be content to rest on its brief.
Seeing none, we thank you both and welcome to the appeals court. I am Justice Meade. With me this morning is Justice Sullivan, and Justice Sachs will be the panel for your case. If we run into any technical difficulties, we'll do our best to reestablish a connection. No one will lose any time. With that, I'll call our next case, 2019 P1148, Commonwealth versus Butler. Ms. Stefani.
Good morning. May it please the court, Lisa Stefani for the appellant Randy Butler. My basic argument is that the Commonwealth did not legally prove that Mr. Butler was under the influence of alcohol. To put the factual underpinnings of why I say this is, on that day, Mr. Butler got up at 5:30 in the morning. His life was sort of quote unquote in a mess, as he described it to me. He lived in his family's home, and he couldn't afford the mortgage payments because it was based on having two incomes, and his girlfriend had left him. He was working two jobs. He was, and then on that day, one of his co-workers came and told him, "You have a flat tire." So what happened then is he couldn't afford to get a new tire, so he got fixed a flat. And so then he finished his work. He went to have a dinner, had 2 beers, left, played some pool, and left around 1:30 a.m. And while driving home, the tire that was low earlier was flat. So, and he was driving down Route 20 in Auburn, and then he drove by some Auburn cops, and they pulled him over. And my contention is that just smelling alcohol is not legally sufficient. He was probably guilty of negligent operation of a motor vehicle. He should have stopped the car. He should have done things differently that evening. But
Ms. Stefani, there was more than him just smelling of alcohol. He was speeding. The speed limit was 40, and he was going 60 on a flat tire. He had bloodshot eyes, slurred speech. He could only narrow down to 2 towns where he was coming from. He almost fell during the 9-step test. He admitted at booking that he shouldn't have been driving. He was unsteady at his feet at the scene and at the police station. He had trouble spelling his name and reciting his phone number. And then he took all of his clothes off in the cell.
But he was just totally messed up other factors that evening. He wasn't, as he said, he shut down, and he was so that maybe, he was just totally psychologically
dysfunctional at this period of time in his life. And I understand it could be that having the 2 drinks was contributed to this, but that doesn't mean he was legally intoxicated.
Okay. Is there anything else you'd like to tell us?
No, but I think that I'm not saying he wasn't culpable of anything. I'm just saying he was not culpable of driving under the influence of alcohol and was legally drunk. No.
I do have one question for you, Ms. Stefani. This is Justice Sachs. You cite a number of articles in your brief about the validity of field sobriety tests. I'm not sure what you're asking us to do with them, where in this particular case, he didn't even complete a field sobriety test because the officer decided it was a danger to him to try to do the 9-step walk and turn because he almost fell over.
Well, I put those in to put some context to what went on here. Because the standard is that if a field sobriety test and the outcome and some of the other factors that were in his case here that evening could prove driving under the influence of alcohol. But my claim, they did not rise to the level because he admits he shouldn't have been driving, but not because he was intoxicated, but because he was driving on a flat tire. So they're just more to put it, what happened in context.
Okay, thank you.
Thank you very much.
Thank you. Ms. Altering. You have to unmute your mic. Kristen?
Can you hear me now?
Yes. Can I
Yes,
reset the
I can
clock,
hear-
Kristen?
Yes.
I'm sorry about that. May it please the court, Susan Oftring on behalf of the Commonwealth. The Commonwealth asks that this court affirm the defendant's convictions, viewing the evidence as this court will in the light most favorable to the Commonwealth. The evidence was sufficient, if not overwhelming, to prove beyond a reasonable doubt that the defendant was operating a motor vehicle while under the influence of alcohol. The several factors, as Justice Meade pointed out, even apart from the issue of field sobriety, that was indicators of impairment, excessive speed on a town road, driving on a very flat tire. I think there was testimony that it was close to on the rim. He was unable to procure his license. He stepped on the gas accidentally. He was unsteady on his feet. He slurred his words. He had bloodshot, glassy eyes. He was swaying, needed help, both at the scene and back at the police station. And there was other indicators at the police station as well. So all that evidence, again, viewed in the light most favorable to the Commonwealth, was sufficient, more than sufficient, I think overwhelming, to sustain this conviction. And if there's no other question, if there's any questions other than that, the Commonwealth will rest on its brief.
Seeing none.
Live.
Welcome to the Appeals Court. I am Justice Meade. With me this morning is Justice Sullivan and Justice Sachs will be the panel for your case. We'll hope this goes off without any technical problems, but if we have them, we'll pause and reestablish any connections lost. With that, I'll call the next case, 2019 P948, Healey versus Hammond. Mr. Gordon.
I have to unmute. Okay, sorry. There are 3 basic points I want to make here. Regarding the defendant's claim that the summary judgment was not properly allowed and claiming it should have been denied, Hammond cannot and does not dispute the facts found by the judge in support of the summary judgment. He took his money. There was no client letter in those elements. There was never, another point is the defendant claims constantly that there was some sort of attorney-client relationship pre-existing between DePietro and Hammond, and that's a fiction. There was never any attorney-client relationship between DePietro and Hammond before any meeting. And it doesn't matter. It really doesn't matter whether there was or not, because as the court found, Hammond provided legal services to Healey and acted as Healey's counsel throughout the proceedings.
Your statement, Attorney Gordon, highlights what a potential problem is in this case, which is that on summary judgment, the judge cannot make findings. And there was some evidence to indicate that there was no attorney-client relationship, in particular, the attorney's representation that he had told your client repeatedly to get his own lawyer. And there was evidence on the other side that Attorney Hammond had acted as if he were his lawyer. And what authority do you have for the proposition that evidence in that state permits a finding as a matter of law of an attorney-client relationship?
Because as the judge found, Rule 1.7 applied, and the defendant hasn't challenged that. And it was clear.
Rule 1.7 doesn't mean that he was your client's lawyer, though.
No, but there was no pre-existing relationship between Hammond and DePietro. Under the Mailer case, the only claim that there was a relationship is based upon DePietro's testimony in her deposition that 18 months before the meeting, she had called and had a conversation with somebody and recited three things. One, that
my concern is not with the DePietro relationship. My concern is with the facts that I proffered to you, which is solely with respect to the disparate evidence as to what Hammond said versus what he did. Why are there not facts in dispute?
Oh, because he acted as Healey's lawyer throughout the proceedings, even after the meetings. He undertook to represent him. He did his financial statements. He did 2 financial statements post the meetings. He sent them a client letter, which he did not send to DePietro. And under the DeVoe case, at a minimum, he created an attorney-client relationship by implication, or an implied relationship with Healey.
Mr. Gordon?
Yeah.
I think what Justice Sullivan is getting at is that, yeah, those things that you point out all could establish an attorney-client relationship, but there was other evidence from Mr. Hammond himself that disputed that, including his own statements and testimony to the effect that, or his affidavit, that there was no such relationship, and that he continually told Mr. Healey that he did not represent him and encouraged him to get another attorney for himself. In other words, this is summary judgment, and it seems that to me that the judge seemed to resolve the disputes on that evidence that are genuine issues that you cannot do on summary judgment.
Well, no, I differ with that, because his conduct was a conflict of interest, in his claim that he said, I don't represent you, get another lawyer, or you should get your own lawyer, does not rise to the level of the necessary disclaimer. It has to be under 1.7, there has to be at least an informed consent by Healey witnessed in some sort of writing, which didn't occur here. And that's one of the first problems with this disclaimer. It doesn't rise to the level necessary under the facts here. So it was a matter of law.
Counsel, the disclaimer is required if Hammond is Healey's lawyer. The threshold question, as I think Justice Meade and I are trying to get at, is whether or not there were facts in dispute as to whether or not Hammond was Healey's lawyer in the first place.
I don't think
we don't even get to 1.7.
Well, no, I don't think you can avoid that fact because of the conflict. When he sat down with both of them and took the information, confidential information from both of them, to write the separation agreement, at that point in time, he became Healey's lawyer, and that's, I think, what the decision clearly says. Coupled with the fact that under DeVoe, he created the relationship by the by his actions impliedly giving rise to it. So that once that relationship formed either under the 1.7 or under DAVO, that the disclaimer that he had to give had to be at minimum, and I say he couldn't have done it, at minimum had to have an informed consent, of which there is no indication of informed consent, and it has to be witnessed by a writing. The fact is that he created the attorney-client relationship. It was there, and it was something that that existed. And the point at which he gave the disclaimer, he says, "I told him I don't represent him. Get your own lawyer." It was far too late for that, and that's what that's basically.
Could you address why the judge should not have asked question number 2 and why the separation agreement shouldn't have been admitted in evidence?
2 reasons. Number 1, question 2 drew in directly what Meyer says you can't do and what the Sandman case says you can't do, which is to use the conduct of the lawyer as a defense in this case. So that what happened was question 2 brought directly into the case the fact that Healey had agreed to a separation agreement that was written by Hammond as Healey's lawyer, which prejudiced Healey's rights. I mean, Healey didn't not.
Mr. Gordon, didn't question 2 essentially just ask whether or not Mr. Healey got an inequitable or unfair share in the probate court proceedings in the separation agreement?
Well, no, it told the jury, number 1, that the fact that the judge had approved it made it fair and reasonable under 208-34. And the fact of the matter is that's not the standard in this case. The standard is whether he received a settlement that he should have had if he was represented by competent counsel, properly advise him. And in fact, question 1.
Can you tell us, Mr. Gordon, where specifically in the record did you present to the judge how you thought question 2 should have read?
I can go through the appendix, but my position as question 2 was it shouldn't have been given. And I said that several times, that it was improper and it was in violation of the Meyer decision, which said it would be judicial estoppel. My position on question 2.
Question 2 clearly does not bar the jury from considering whether question 2 aims at causation and talks about whether the plaintiff received a share of the estate that wasn't fair and equitable. It doesn't tell the jury that they need to be bound by or are bound by the probate judge's prior decision. So I'm not understanding the estoppel point at all.
Well, because the estoppel point is that the question 2 was wrong on the law and wrong on the probate proceedings, because question 2, because when a judge approves a settlement agreement, the decision is not based upon whether or not the client or the party received what they would have had they been represented by competent counsel. It is based upon what the parties agreed to. In this case, according to the separation agreement, when negotiated by independent counsel, Mr. Hammond told the judge that he had mediated the agreement, which created a different impression.
So where did you say, where did you ask the judge to give a different question to the jury other than question 2?
I had asked.
You think captures the proper standard that the jury should have been looking at?
The proper standard, what I asked for was a 3-part question for number 2, because number 1 found that he did not get what he should have gotten had he been represented by competent counsel. Question 2 that I proposed is, in essence, was A, what was the gross amount of the marital estate? B, what percentage of the marital estate do you believe or do you find that Healey was entitled to based upon the evidence that was heard at the trial? And 3, taking A and B, insert what that dollar number was, because question 1 said that he did not get what he was what he should have gotten. So the only issue on question 2 was how much, or to set forth a number to differentiate what it was that he should have gotten that he did not receive.
But you would
Attorney-
agree, wouldn't you, that even had a better attorney reached a more favorable settlement agreement, it still would have had to have been approved by the probate judge? So
Well,
it's not irrelevant whether it would meet the fair and equitable standards of Section 34, is it?
You broke up, I'm sorry.
Yes. Even if a better settlement agreement had been reached, it would still have had to be approved by the probate judge, correct?
Well, it would have to be approved, right,
Yeah.
but the
So
settlement
it's
terms,
not irrelevant whether that quote unquote better settlement agreement was would meet the fair and equitable standard of Section 34.
well, it would be, because had he been represented by competent counsel, as the jury found, he would have gotten a bigger share of what he got in the settlement agreement, which per se makes that settlement agreement not fair and reasonable. But again, fair and reasonable is not the standard in this case.
But there are
The fact
multiple
that- I'm sorry.
multiple settlement agreements that could meet the fair and reasonable or fair and equitable standard, aren't there?
Well, but under Anson, the issue for the judge is whether the parties have agreed in an arm's length arrangement that this is, and they find it fair and reasonable when they're represented by independent counsel. The problem here, not being represented by independent counsel, was that Mr. Hammond represented both sides, and there's no indication that he ever advised Healey as to what his share would have been or appropriately was after a 26-year marriage. So
Mr.
that
Gordon,
the issue is,
Mr. Gordon, can you argue in your brief the separation agreement should not have been admitted into evidence?
yes,
I don't understand that, and maybe you can enlighten me about a case or a rule that prohibits the admission of an agreement that sets out the terms of what actually occurred, and how, pray tell, would the jury know they were unfair if they didn't know what they were?
my argument on that was derived partially from the Troyanker case, where you had an attorney who negotiated a settlement agreement for both sides that he was representing. Troyanker said the agreement was void. My view of the case was that Hammond, in a conflict of interest, acting as Healey's lawyer and apparently in his own mind acting as both lawyers, a lawyer for both, the agreement per se cannot be valid because it was not the product of a proper negotiation. It was a result of an attorney acting in a conflict of interest, by which, as Mr. Aaron testified or provided in his affidavit, that somebody's going to get hurt by that type of arrangement, because you can't have fiduciary duties to both parties in the same transaction and then not expect somebody to come out on the short end in that situation.
Mr.
Which is
Gordon?
why I argued.
We don't have too much time left. So I want to make sure you address the defendant's argument that without the testimony of Mr. Healey available, what evidence was there that he would have even sought a better or a settlement agreement that gave him more of the property? In other words, the defendant says his interrogatory answers were stricken, and on summary judgment, there was no evidence that even if advised differently, he would have actually sought a different settlement agreement.
In the summary judgment, the question was whether or not Hammond had breached the duty towards Healey, which was whether or not he was in a conflict of interest, which was the argument, and under DeVoe, which was the issue at that point. So the summary judgment didn't really go to.
Well, the defendant's summary judgment motion did go to the point of how could you expect to prove causation at trial if there was no evidence that Mr. Healey actually would have sought a better settlement agreement?
Well, the evidence of that, number one, comes from the fact that he filed the suit saying I didn't get what I wanted.
But he was found incompetent, at least to the extent that his interrogatory answers were stricken. What expectation did you have at trial of proving what he wanted?
Well, I think
a verified complaint.
Pardon?
This was not a verified complaint. There's no evidence from Mr. Healey himself in the record, is there?
Well, I think there is evidence in some of the material that was submitted, because he said at various points he's talked about he was wronged by Hammond, and he didn't get what he thought he was entitled to get. I mean, he didn't necessarily say, I wasn't
Where did
happy
he
with
say
it.
that?
I'd have to, I'm sorry, I just can't off the top of my head go back to that right now. But I think it was enough evidence in there.
That's an important point. If there's somewhere that he said,
I can't
perhaps you can let us know.
right this minute.
You can send us a letter, Mr. Gordon.
Pardon?
Send us a post-argument letter.
Okay.
Under Rule 16L without argument.
Within 7 days.
Okay.
Any other questions? Okay, thank you. Attorney Green.
Thank you, and may it please the court. My name is Matthew Green, and I represent Attorney George Hammond in this matter. I think the primary question that is raised by the plaintiff's appeal it focuses on the conduct of the jury trial, the inclusion of question 2 on the verdict slip, and the effect of question 1, where the jury came back yes on 1 and no on 2. And I think to understand the context in which that verdict slip was crafted is important in this matter. First of all, what the judge did was correct. The legal standard in this legal malpractice case is set out in Fishman v. Brooks. And Fishman v. Brooks articulates 2 separate approaches by which a legal malpractice claim can be proved. The first is by far the more prevalent. It's the so-called trial within a trial. And the majority of the Fishman opinion deals with the mechanics of this trial within a trial. But it requires that evidence that would have been put on in the hypothetical lower case but for the negligence be presented to the jury in the legal malpractice case so that they can determine whether or not the malpractice existed and whether or not it had any cause or effect. The second, which is articulated in Fishman Note 1, the second approach that is more simple and doesn't require the trial within a trial. It requires simply evidence that a reasonable settlement range existed and that the settlement that actually was reached was below the bottom of that range. Now, throughout this case, plaintiff's counsel refused to articulate which of those 2 approaches he was going to present at trial. And this created a problem for the trial judge. Justice Sachs, to your question, I would direct you to the Record Appendix Volume 41 at page 14, which is actually the plaintiff's proposed jury instructions. If you look at those very plainly, they ignore the effect that causation is even a live issue in this matter. I believe the first question that the plaintiff proposed was, in fact, liability has been proven. The only question to you, jury, is to determine what the amount of damages is. I would also look at the charge conference, which is more of a dynamic conversation.
Counsel, what was the citation for the first item you mentioned?
It was the Record Appendix Volume 41 at page 14. And the second citation, while you're writing, is for the charge conference, which is in the Trial Transcript Volume 7 at page 32 through 43, which is a more dynamic articulation of the respective sides of the parties and the judge's attempt to wrestle with this. In the charge conference and in the proposed jury instructions, plaintiff's attorney refused to adopt a Fishman standard, to choose one of the 2 paths. I think his position remained one of essentially strict liability. Based on the summary judgment on duty and breach, the only question to the jury is damages. Based on the absence of information provided by one of the parties, I think the judge erred on the side of caution and crafted a question which was not requested by the defendant and was not requested by the plaintiff either, which is...
If I could just interrupt you here, though, when I read the charge conference, I see a long discussion of question 1. And then I see on page 46 an effort by Attorney Gordon to say, well, number 2 should not be fair and equitable. That's not the standard. It's the standard of whether the defendant met the standard of care in representing. He's then cut off, and the judge says, are you talking about the verdict slip? He says, yes. And she says, we're off the verdict slip because she imposed a 9:30 a.m. deadline on bringing the jury in. So my first just practical question is, was this question 2 ever really fully discussed at any point, either that morning or any other morning or afternoon for that matter?
It was. Earlier in the charge conference, we had discussed this. It was also in the motions in limine and the motion in limine hearing, which I believe.
Well, if I could just stop you there. Earlier in the charge conference, and correct me if I'm wrong, I had understood the discussion to be primarily about question 1. There's a passing reference to questions 2 and 3, but I didn't see a long discussion of question 1. I just want to make sure I understand the record correctly.
Of course. Looking at pages 32 and 33, I think is probably the clearest example of what was an unclear exercise. And it's really the dynamic between 1 and 2. The argument I articulated was that question 1 in a vacuum is confusing with question 2 because it doesn't talk about the subjective intent of the plaintiff. My point to the trial judge was that if you're going to include question 1, which is a more standardized Fishman approach, the Fishman first approach, the trial within a trial, then it has to account for the plaintiff's subjective intent, i.e. he would have sought another result.
I hear you, but can we agree that what's on page 32 of that volume is primarily about question 1? I know what you argued. I read it carefully.
Okay.
Is there, you said in the motion in limine, this was also raised. If so, can you point us to where, and we'll look at it after argument. I want to let you get to your other points.
Of course. I would look at page 34 while you're on that reference.
Okay, I have.
Okay. Attorney Gordon brought up specifically 208-34 and argued against it. I think he had been heard on that issue. And seeing that you've have a good familiarity with the record, I won't belabor the point. As far as the motions in limine, there was a motion in limine, I believe it's in trial transcript 6, and I apologize, I don't have the exact page reference, but there was not only, first of all, the motion in limine hearing was broken over 2 days, and there was a significant amount of time spent on what the legal standards would be, and in fact, what the issues that remained for trial. That included a robust discussion of the applicability of 208-34, and really more philosophically, what the evidence at trial would be and what the burden of proof was, because at that point, even that was disputed. So if the point you've raised, Justice Sullivan, is that Attorney Gordon was perhaps unfairly cut off when articulating a point about the applicability of 208-34. I would look to those 2 separate motion in limine hearings, and I think a much more detailed conversation was and articulation of the dispute was recorded.
So are you suggesting that question 2 embodies the second approach you identified from Fishman v. Brooks that was in a footnote?
Yes, I am. And I think what we're left here with is entering into trial. It was unclear whether the first or second approach would be utilized by the plaintiff who had the burden of proof. I think in abundance of caution, the judge included both questions. Now, the first question was dispositive, but not prejudicial error. I'm sorry, the first question was not dispositive, but also was not prejudicial error. It was simply superfluous because the evidence at trial was not a trial within a trial. But first and foremost, for the most glaring reason that the plaintiff was not able to testify, but also the evidence that was presented by Attorney Gordon on the plaintiff's behalf did not encompass the trial within a trial approach. So the yes on 1 is not dispositive of the issue because it did not match the trial evidence, but also the interplay between the 2, which was contemplated by the trial judge during the charge conference. In fact, she says that based on the verdict slip, the jury could come back and say that he might have been able to get a better result, but did not want a better result based on the evidence that's been presented. Or in turn, that the jury could determine that a 50-50 split is not something that people entering into a voluntary divorce are entitled to, that in fact, a much different split can be determined to be fair and reasonable under the statute, and in fact ratified by the probate court.
Is there some disconnect, though, between the jury instruction that was ultimately adopted, which was essentially could a better result have been achieved jury instruction? I mean, there the discussion was fully vetted and the instruction was modified in accordance with the arguments of the parties. I'm having difficulty squaring what the jury instruction said with what the question said, particularly question 2. Not so much question 1, which tracks with the instruction, but question 2, which would appear to apply a different standard. How do we reconcile those?
Well, I don't think it's a, first, as I articulated Justice Sachs, I do think that they embody the two different approaches. And I think that the jury was, although not instructed on separate lanes, in other words, that this is Fishman approach 1, this is Fishman approach 2, tracking directly with question 1 and question 2, I think they were provided instructions regarding, first of all, the Fishman 1 approach, the trial within a trial, because again, I think the trial judge opted to include that in a belt and suspenders context. I don't think that question 1 was ever intended to be dispositive on its own. As far as the instructions for question 2, it had to do with Jerome Aaron, who was the plaintiff's expert, who not only testified extensively regarding the factors of 208-34, included a chalk in his testimony regarding the factors of 208-34 and how he thought they were applied, as well as it was deposition exhibit 3, I believe it was trial exhibit G, but don't quote me off the top of my head, was in fact the statute. So I believe that the trial, where the evidence had been so directly related to the statutory factors, the instructions regarding the weight of expert evidence, in fact, instructed the jury how to apply statutory factors and what the ultimate burden of proof was.
Can I ask you, Mr. Green, on your appeal, you challenged the motion judge's finding as a matter of law that there was liability. If you were to prevail in the rest of this appeal on the damages issue, what effect does the finding of the motion judge have after that? In other words, you're not looking for a new trial, right?
No. Legally, it would be none. If the jury verdict is affirmed and the flipping of the summary judgment on liability in my client's favor, it's simply an independent grounds to affirm if in fact the jury verdict is reversed.
Right.
That said, that's the legal effect. I will say that I represent a practicing attorney, and it matters to him that a judge has said you at least had a duty that you breached, which he vigorously denies and believes that that was legally incorrect. So although reversing that summary judgment would not have a legal effect provided that the jury verdict is affirmed, it's an important professional point to my client.
I understand.
Can we talk about the sanctions for a minute? I'm concerned that the judge's order awarding sanctions cited as an example of improper conduct pursuing frivolous interlocutory appeals. Yet she didn't award any costs or attorney's fees for time spent on those. It's doubtful that she could, being in the trial court and those proceedings occurring in appellate court. And I don't see from even your recitation of the proceedings in your brief how those interlocutory appeals delayed the progress of the trial court proceedings or otherwise interfered with the administration of justice, which is the standard that the judge was purporting to apply.
Of course. The interlocutory appeals I saw as almost a minor footnote, and it wasn't the argument that was articulated in the multiple sanctions motions and was eventually relied upon by the court in awarding sanctions was not that the interlocutory appeals in a vacuum were somehow improper or that even fees associated with those interlocutory appeals could be awarded. It was more holistic, to be perfectly honest with you. This is a pattern of conduct that had happened over the course of almost a year and a half or 2 years. starting really with the plaintiff's deposition, and then repeated motions which disregarded prior orders of the court. So I think that the interlocutory appeals were not themselves in a vacuum sanctionable or were adjudged as such by the session judge. What they were was a pattern of conduct by Attorney Gordon that he is not going to accept any order of the court with which he does not agree or does not accord with his view of the case. And his repeated relitigation of settled issues is what resulted in drastically higher attorney's fees associated with the defense of this claim, but also increased the length of this litigation. So I agree with you. I don't think that the session judge had the ability to award fees based on interlocutory appeals, but the pattern of conduct was to be lumped in with the greater pattern, all of which resulted in the award of sanctions under the administration of justice, as you articulated.
The sanctions themselves were not itemized as they related to conduct, though, right?
My memory is that the memorandum and brief regarding the assessment hearing was itemized. I think that if you do the math, you can figure, not if you do the math, but if one were to do the math, they can figure out which itemized motions were.
She lists which ones. She lists them by dollar amount, but there was no evidence of the time spent or exactly how the time spent. It was just a lump sum in your affidavit for each of those proceedings.
That's correct, and I weighed
no evidence of hourly rate. No
right.
Number of
I
hours.
addressed that in the hearing, and I was very candid with the court that I had never experienced something like this before, and I had never even moved for sanctions before. My point in proffering to the court what I did was that this is an active litigation. I can't give my billing records because it contains attorney-client privilege communications as well as work product. What I did offer to do, and you'll see in the hearing, is provide an in-camera review to the judge. I had the billing records with me, and I offered them to the court. And I said, if you want to conduct an in-camera review regarding a more precise lodestar method of determining what the fees are, I invite you to do so, but I can't just hand that over to opposing counsel where we have trial in 2 months. The judge declined to do so. I look at that as an implicit, if not explicit in the order, an implicit acceptance that the dollar amount was within the range that would be acceptable of a reasonable fee and time spent. And I think that if not explicit, at least implicitly applied the correct methodology.
The other alternative, of course, was to wait and to finalize the amount of the sanctions until after trial. I mean, producing billing records in attorney's fees cases is something that litigants do all the time, and there's a limited waiver of the privilege for the purpose of doing it.
Agreed. If the court had asked me to do so, I certainly would have, but it was set for a sanctions assessment hearing, and the court requested evidence. So I tried the best I could to provide the court with what I could without prejudicing my client.
We're gonna have to, you're out of time, so we'll leave it there. Snafus, and we'll get through this without interruption, but if we do, don't worry, we'll reestablish your connection and allow whomever should that occur to finish their argument. With that, I'll call the next case, 2019 B 1525, Merrimack Mutual Fire Insurance versus Ellen GIUNTA. Mr. Goulet.
Yes, Robert Goulet on behalf of Merrimack Mutual Fire Insurance. Can you hear me okay?
Yes.
And I guess before I start, I'm wondering if there's a ruling on the motion to strike that the defendant had filed.
We have not decided that yet.
Okay, so this case is about a case looking at a lease where the court looked at a lease to determine the party's intent. And obviously, I know you've read the papers. It's about a case that the court found, pretty much relying on a single clause, the yield up clause, that there was an intent for the parties to be co-insureds here in this case. The court relied on a lease that was not properly before it. It was not submitted with an authentication with an affidavit by the defendant's counsel. And the court not only relied on the lease itself, not properly before it, but also inferred facts from the lease that were not independently corroborated anywhere else. The most significant of which was whether the lease, in fact, was still in effect.
I have a question about that, Mr.
Yes.
Goulet. I recognize that the lease on page 1 says it expires on March 31st of 2015, but the lease on page, well, I can't say what page, but I'll just say paragraph 9, Record Appendix 1, page 127, says the lease ends at 12 noon on March 31st, 2016, which would be after the fire. So there is a conflict within the lease itself about when it ends.
Yes, I think that's true. And I noticed that, but I don't think that, I apologize, but I'd have to flip through the lease to direct you to it. But my review of the lease indicated to me that the controlling date was 2015 and not.
So assuming that the lease had expired, there was some discussion, I think, by the judge of a holdover provision that required the landlord's written consent.
Yes.
There's another provision, paragraph 29, the overholding provision, that covers what happens if the tenant continues to occupy the premises without the written consent of the landlord. And then it says, without any further written agreement, the tenant will be a month-to-month tenant, subject to the other provisions of this lease insofar as they're applicable to a month-to-month tenancy. So even if the lease had expired, under the terms of the lease, a month-to-month tenancy was created subject to the applicable terms of the lease. Which terms are applicable?
Well, that's, I think, the point of the lack of other corroborating evidence. So even if the lease itself suggests that there was a continuing, the provisions continued to apply, there was a month-to-month, we don't know. There's no other facts put before the court. And I don't say this, it's not a small fact that we don't even know if the tenant was still renting the premises. There's no other independent fact that suggests that or that corroborates that was submitted.
She was clearly there and she was clearly doing laundry. We know that much.
Sure. She might have. And I tell you this, I don't know this. I wasn't the attorney on the case at the time. I don't know this. I don't think we do know it from what I've reviewed, whether or not they were there continuing business or whether they might have been in the process of clearing out that space. I do know that, again, I don't know where it is in the lease, and it might have been in some other papers, not before the court, but I do know that the lease had expired 8 days before the fire. So
Counsel, just in the world of what we do and don't know, one of the things that we're told we're supposed to rely on is the joint statement of facts under Rule 9A-5. And Record Appendix 1, page 26, the second, it's a very brief joint statement of facts, but it says that there is a lease of the first floor of the subject premises between, and it names PL, Dimitros Skivlas, the defendant, Ellen Gunther, and Bliss, covering the dates of the fire on or about April 8, 2015. And the response is not to say that there's no lease. The response says Merrimack Mutual disputes that it was a party to the lease. It doesn't say there's no lease. And goes on to say that it disputes that the lease was in effect at the time. Yes. But I've read this to you simply to point out that in the joint statement of facts, there's no place marker for claiming that there's no lease.
Well, I think that the way
or
I
that
read
it's
that,
unauthenticated.
I'm sorry.
Or that it's unauthenticated.
Well, I think the dispute there is whether the lease is still in effect, and I think that goes to my point that we don't know what the circumstances were at the time of the fire, because it is directly disputed that the lease remained in effect.
Right. But my only point is you've also made an argument that it's not authenticated, but I don't see that raised in the joint statement of facts.
Oh, okay. Well, I think that argument is raised before the court during the motion for summary judgment hearing.
I know, but I don't know that you can do that if you don't put it in your joint statement of facts. Typically, what's in a joint statement of facts is deemed admitted.
And I think that there was a motion to strike the language. There was a motion to strike the language that suggested that the I don't know exactly what the quote was, but there was a motion to strike that was filed.
That was directed to paragraph 3. We're talking now about paragraph 2, which alleges the lease.
And the facts are what they are in terms of what was filed and what was said before the court. But I think collectively, I think the issue was raised as to the authenticity of the lease. I think that
it was raised, but the question was it raised too late? There are other cases which suggest that once there's an admission in a joint statement of facts, that everybody's bound by it.
Understood, Your Honor. And I think that the admission there, if there is one, was that there was a lease. And the question is whether this is the lease and whether or not this is the authenticated lease. And on that point, I think, obviously, I'm happy to answer any further questions on that.
Yeah, we can move on.
Okay, the lease itself. So moving on to the lease itself, this is not really a case that, as I set forth in our brief, this is not a case where the yield up clause controls everything. I would go so far as to say, if you look back at Peterson, even in the residential context, while the court relied on that yield up clause, the Supreme Court, SJC, it wasn't solely reliant on that. The court also commented that elsewhere in the lease, there were other corroborating provisions, even in the residential context, where we get the Peterson rule that suggested that, in fact, the intent between the parties was that the defendant landlord would maintain the insurance. In this lease, the lease speaks for itself. There's obviously a yield up clause, and it has similar language as to an exception for fire and wear and tear. But, I cited a case in my brief all the way back to 1864, Ball versus Wyeth. It's that, and I cited that for a real reason. There were 3 competing clauses in that case. It's still good law. And the Supreme Court said, well, look, when we have these competing clauses, just because there's a yield up clause in a commercial context doesn't mean that trumps all other clauses. We need to look at the entire lease.
Mr. Goulet,
yeah.
You've made some very creative arguments in your brief about different provisions of the lease and how they might indicate a different intent than if we looked at the yield up clause alone or together with the keep and maintain clause, which the judge also relied on. My problem with your argument is that many of those provisions weren't cited or argued to the motion judge. And so haven't they been waived?
I don't think so. I mean, I don't think so under the rules. I think under the rules, the controlling law says we have to look at the provisions of the lease. I'm not sure that it's incumbent upon the non-moving party to raise each and every potential argument in the lease as to why the court should not rule in favor of the moving party.
You may not have to give every argument you have, but if you give the arguments you choose to give and then the judge rules against you, can you come up on appeal and make some other arguments as to why the judge was wrong that were never presented to the judge? Don't you have your one shot at convincing the judge, and then based on what you argued and how he dealt with those arguments, then you can appeal?
I mean, that's not the way I understand it. I think the argument is before the court, the moving party has the burden to show that there are no disputed facts and that the lease itself relieves the party, the defendant, the intent of the parties. So the issue isn't what the lease says in each and every paragraph, it's what's the intent of the parties. Normally, the intent of the parties is left as a decision by the trier of fact. In this case, we have competing provisions, even the ones argued before the court, such as a mandatory waiver of subrogation for one party and an optional waiver for the other. There are competing provisions within the lease that were pointed out to the court that should suggest to the court that relying only on a couple of provisions doesn't get the court where it needs to go. And it's the moving party's obligation to show there's no disputed material facts and to show that the party's intent as a whole can be gathered from that lease. In a case where the court decides that the lease is unambiguous, the court, that's a decision made as a matter of law. The court must look at the entire lease to determine whether or not it's ambiguous. I don't think the court can just focus on the provisions cited by the moving party and say those provisions aren't ambiguous, when there are other inconsistent provisions that make the reading of the contract as a whole ambiguous. And I do think that that's the court has the right to determine whether it's not whether or not it's ambiguous as a matter of law, of course. But in so doing, I think the court has an obligation to look at the lease as a whole and all the provisions in the lease, not to simply focus on the ones brought to its attention by one party or the other.
You would agree, however, wouldn't you, that this case is different than Barbosa? Barbosa relied on the fact that the yield up clause, quote, lacks an unqualified exception for fire damage, close quote.
It's different. I would agree it's different in that respect, but I think Barbosa stands for the proposition, and I compare it back to the Lexington case. There really wasn't much analysis in the Lexington case, and I think that's significant because it came before Barbosa. So the Lexington case, the court did just look at that yield up clause. But I think in light of the Peterson case and then the Barbosa case coming afterward, the Supreme Court of Massachusetts said, look, we have to look at the intent of the parties as set forth in the lease. And that is not just to focus on the yield up clause and say that that's a trump clause no matter what, especially in the context of a commercial lease, where in Barbosa, the court was careful to say that a commercial lease is different than a residential lease, in the sense that the parties are sophisticated and it's understood that the parties may allocate liability and insurance between themselves, not in the case of a residential where you might assume as a tenant that you're covered by a master policy. And there are express provisions in the lease that make clear the parties intended to allocate liability for insurance, certainly, that the primary insurance was always to be the tenant's insurance, that the tenant had a liability insurance that had to be maintained, and the repair clauses and other clauses in the lease, it's quite clear that when there's damage to the premises, there's damage to the building, the landlord will repair those damages, but unless those damages are caused by the tenant. So the lease itself.
Mr. Goulet, your brief points to paragraph 43A, the requirement that the landlord maintain extended fire and extended coverage insurance on the building. That seems like some kind of insurance term of art, extended fire. Does that necessarily mean it's secondary to the primary insurance that you say the tenant was obligated to maintain, or does extended fire just mean fire coverage that may cover types of damages beyond the usual standard fire clause or something else?
Candidly, I sort of tried to figure that out, but I was not able to. I looked into that, and I don't know. In all candor to the court, my background is not in insurance law, so it may be. I do not think it's a term of art. I do think it's clear in the lease, however, that all of the landlord's insurance was to be considered excess insurance, and all of the tenant's insurance was to be considered primary insurance. And I do think it's significant that, I know my brother argues that this case relies upon just a general liability clause. It does not. It's not a case that there's just one clause that says the tenant is required to maintain general liability insurance. It's a case where that clause is very clear. There are numerous other clauses that clearly allocate to the tenant responsibility for their negligent behavior and requires insurance for all property damage for their negligent behavior. So we're not allocating generically if something happens to the property, but if it happens in such a manner it's the tenant's negligence, they're responsible for it, as opposed to an overriding extended insurance, as Your Honor points out, that might cover for all other manner of damages.
Okay, Mr. Goulet, unless there are any other questions, we're going to leave it there.
Thank you.
Thank you. Mr. Maskus.
Members of the panel, may it please the court. Michael Maskis, representing the defendant, Palisio and GIUNTA in this case. I would just like to, I'd be happy to address any issues the court has regarding this, but I would submit that the judge made a careful and thorough consideration of the facts in this case at the lower court, and that the issue that have been raised, first, whether or not the lease was admissible, was dealt with by the judge. There was a lot of discussion by it, and we, as I stated in my argument, the lease had been produced by the plaintiffs in their production of documents, and also had been produced in a 30B6 or a subpoena ducis taken to the landlord. So that notwithstanding the fact that the judge found it admissible, if we were in a courtroom trying to enter this lease into evidence, we certainly would be able to call it a business record as well. We submit that on that issue, the judge ruled appropriately. And then the crux of the case and the main drive for our case is that my client should be considered an implied co-insured under this lease.
Can we just pause there and touch on the authentication issue? Once this was raised in the insurer's opposition to your summary judgment motion, and once it was raised at the hearing, why didn't you file some sort of affidavit, either from yourself saying it had been obtained in discovery or from the client saying where she got it, something to take this issue out of the case? Because we really don't have anything before us clearly indicating that this was the actual lease or that it was in effect.
I think I addressed it with the court in the oral argument, and I also produced for the judge the subpoena ducis taken from the landlord, so that the way the judge.
You produced for the judge the subpoena for the landlord?
I did at the hearing. It was not entered as an exhibit. The judge he basically, as you can see, I think I quoted the exchange there in my brief. The judge just moved on from that issue right at that point when I raised it.
But I certainly didn't see insurance counsel, a different counsel than Mr. Goulet, waiving that point during the argument.
Well, actually, the judge said, does anybody have a problem with it? And there was no answer from insurance counsel.
And I would say, contrary to what the counsel's brief says, there was not a motion to strike on this issue. The motion to strike there was a formal motion to strike filed, but it had to do with the form of the motion where I had underlined the key language, which is not, which counsel pointed out to me is not allowed under Rule 56, and I just amended that motion, and the motion to strike was never ruled on because I conceded that point. So again, if the court please, I would like to address the issue of my client's status as an implied co-insured under this lease. If we're past that issue of the lease itself, I would submit.
Well, I want to make sure you address the issue of if the lease had expired, then under paragraph 29, which is the overholding provision, it says if there's a month-to-month tenancy created, then the terms of this lease, insofar as the same are applicable to a month-to-month tenancy, will remain in effect. Which terms are those?
I would say the terms of the lease. The obligations under the lease would continue. There's no provision for them to change. my client still has her obligations under the tenant's affirmative obligations as defined in that lease, and the landlord has his obligations. And the status, I say, would continue under the terms of the lease. Regarding the yield up clause 80, clause 82, I would say that is the clause that that we point to that indicates that there was no contemplation for my client to purchase fire insurance, and that the landlord was, in purchasing insurance for the entire building, was including the tenants within that lease. And I cited those line of cases. I think you discussed them a little earlier. Peterson v. Silva, Lumber Mutual versus Old Tech, and the Lexington Insurance versus All Regions Chemical Labs. And I would address the issue of the Seco case, which was cited after Peterson v. Silva. I would submit that case did nothing to change the way a court would interpret a yield up clause. In that instance, in those circumstances, they declined to address an issue for a commercial lease.
What do you say to the argument, though, that you need more than the reference to to exclusion of fire in the yield up clause, that you have to look at the agreement as a whole, and if you look at the agreement as a whole, then clearly the responsibility for insuring against various liabilities was shifted to the tenant?
Well, no, that's not uncommon for tenants to have obligations for insurance, but fire insurance is a very separate category, and specifically is excluded at different, also in clause number 62, which is the maintenance clause. The same language comes up where they're accepting for damage by fire, so that there is no provision in this lease that says the tenant has responsibility for any fire insurance, primary or secondary. Regarding the evidence that was before the trial judge, I'd just like to comment on that the judge did have sufficient evidence to make decisions in this case. When he was there, he had the pleadings, he had the statement of facts as indicated earlier, but he also had commercial business document that had been signed before witnesses. The entire lawsuit is premised on the fact that my client was a tenant in possession of the premises at the time the fire started.
I actually didn't see that in the complaint. I think I saw a reference to your tenant's negligence having caused the fire, or the defendant's negligence having caused the fire.
But the circumstances and of the situation is she's clearly on the premises, and they allege that her employees, not her herself, they said her employees,
her employees,
yeah, caused the fire with the towels. So it's a fair interpretation of that language. Employees means they're operating a business. And if you combine that with the lease itself, again, the judge had evidence that there was an agreement witnessed for my client to be paying rent, to be conducting a business there, that she had performed her duties under the lease, if you look at the terms of the lease, her conduct was consistent with the terms of the lease. So the judge had sufficient circumstantial evidence to put this lease into a context.
I want to return to a question that I raised earlier and that I'm not sure I heard the answer to. Once this issue was raised in the insurer's summary judgment opposition and at the hearing, why didn't you just take it out of the case by filing something authenticating the lease? I mean, should we infer that you were not able to, or?
No, Judge, I wasn't able to. I honestly did not believe that it, at the time, didn't believe it was a viable argument, given the clear fact that that lease had been produced in discovery as not only as the lease, in our when I requested the lease that they paid their subrogation amount to their insured, but also, as a business record from the insurance company and how they're conducting their business. So I would say on both those theories, it goes into evidence and is properly.
Well, even business records have to be authenticated, don't they?
But if they are in that context of being produced by the plaintiff themselves as their business record, I would say that's the authentication. If the court does not have any other questions of me, I think I waived the remainder of my argument at this point. My time.
Thank you. Seeing none, we'll thank you both and take this under advisement.
And we are live.
Better.
Yes, thank you. Welcome to the appeals court. My name is Justice Meade. With me today is Justice Sullivan and Justice Sachs will be the panel for this case. Each side, we good? Absent any technical difficulties, each side will be provided 15 minutes and there's no rebuttal. With that, I'll call the last case 2019 P1375 Hsbc Bank versus Relisa Palisio. Ms. Palisio.
Good morning, and thank you, Your Honor. My name is Relisa Palisio, and I'm representing myself and my husband, Pedro Palisio, and we are the defendants in this matter. This case involves an appeal of our opposition that was stricken and not considered by the housing court due to being untimely and in contravention to his order, while allowing the plaintiffs to also be in contravention to his order without any consequences. And the denial of a motion to reconsider that order, also allowing plaintiffs' motion for summary judgment while a matter of material fact was clearly disputed, and a foreclosing creditor also does not have available res judicata defense to a post-foreclosure challenge to title or possession. And on February 22nd, 2019, we filed our answer to the plaintiff's summary process complaint, along with discovery requests and interrogatories. One of the issues were the unauthorized practice of law with the potential of a violation of the good fund law, of which we would need an affidavit to support our opposition pursuant to Mass Rule of Civil Procedure 56F. We believe there was equity skimming, as the lender charges exorbitant fees and then gave us a refinance modification that was $78 less than what we were paying. And at the time we were paying about $33,566. And on October 16th, after filing a motion to compel, we received boilerplate objections to our discovery request. On April 23rd, we filed our motion to compel, to enforce or compel further discovery. And we scaled down our request to all the closing documents in communications that would provide the name of the closing agent, because the name was illegible. On May 8th, prior to the scheduled hearing of May 21st, for the motion to compel, the plaintiff produced supplementary supplemental discovery, but it was just a portion of the closing documents. And
Palisio,
yes.
may I interrupt and ask you, I think we know the facts about how the judge disregarded your summary judgment opposition because it was late, and your argument that he should not have done so while also excusing the late discovery responses. But let's assume that he had not done so and that he looked at the arguments made in your summary judgment opposition. Why would those arguments not be barred by the fact that you could have raised them in the Essex Superior Court case but didn't, and therefore res judicata or claim preclusion bars you from raising them in this case?
Okay, Your Honor, when I first looked at the notice of default in 2014, I had an attorney at the time. So I just kind of glanced over it. And because of the language, the vagueness of the language, I wouldn't have been able to bring it up at that time.
Did you have a full copy of the notice of default in 2014?
I did.
Yeah, so when you filed the Essex Superior Court complaint, you had a full copy, not the redacted copy that we saw in the record, but a full one.
No, I did not. I didn't have it with me at the time. I was just going by their copy because that was in 2014.
Okay.
So I looked at it.
So the copy that you had from them in 2014, did that have all of the pages?
Yes, Your Honor, but it was so vague and it was deceptive. I wouldn't have known. To me, it appeared to be correct when I first looked at it. And then when I went back and I looked at it again, once I realized that it was redacted, and the disclosure pages was omitted, that's when I realized that it was potentially deceptive.
But the disclosure
When you got it,
sorry, go ahead.
Sorry, when you got it again in this litigation, you realized it was different than what you'd had before.
No, it was what I was going by because I briefly looked at that notice in 2014.
Yeah.
And to me, it appeared on face value to be correct. And when I went through, when I was attempting to oppose my motion, I went through the documents that the exhibit from the summary judgment from the plaintiff, and it was really redacted. So I pulled it out. I pulled it out and I found it, and the disclosure page was missing from their exhibit.
In this litigation, in today's litigation.
But you had it in 2014.
But in 2014, you had it.
Right, but it was vague, that the language was vague, and it appeared to be correct. When I first read it, I just assumed that it was right until I had it back.
And in 2014, you also had a lawyer?
I did.
Okay.
I believe at that time I did have a lawyer, yes. So, yes, so because of that, and even if that's, even still, Your Honor, this issue was, because this is a foreclosure, I'm sorry, can I just take a look here, please? If my motion was considered by the court, because it's a non-judicial foreclosure, the creditor would not have available the res judicata defense when I'm challenging the title or possession. So even if that was the case, if my motion was not stricken, there res judicata should not have applied.
Right. Well, the judge actually did consider your argument, which is the interesting part of this. He struck it as being too late, but then he addresses some of the issues that you raised.
Right.
And typically we use these Latin words, which are not all that difficult to make out. But basically, the point of res judicata is that if you've already had litigation where you could have raised an issue, and you did have litigation back in 2014, you're supposed to raise all of your claims at that time. And that's the issue that we have to decide.
Right.
It's kind of all or nothing, one shot deal kind of legal principle.
Well, how can I raise an issue when like I said, at face value, the notice appeared to be correct. So the language was vague. I wouldn't have known that it was a potential violation of the power of sale until I went back and researched it, because it just appeared to be correct. And I'm sure it wasn't just me, but plenty of people have read it and assumed that it was correct. So that's the reason why I could not bring it up during the past cases. And can I just take a look, please, at my paperwork?
Take your time.
So I'm not sure if I got the restatement correct, but restatement second says contractual language that is ambiguous if it is susceptible of more than one meaning and reasonably intelligent. And a reasonably intelligent person would differ as to which meaning is the proper one. And that's citation, insurance, and Gomez. And that's what I believe happened here, because I did read it and it appeared to be on face value correct.
So you're now talking about whether the notice about your right to cure and by when you had to make the payments was strictly in conformance with paragraph 19 of the mortgage? Is that what you're...
Could you repeat that, sir?
Yes. So are you getting at whether the notice that you received from the lender or the holder of the mortgage, when it told you about your right to cure the default and by when you had to make full payment to cure the default, was not strictly in accordance with paragraph 19 of the mortgage? Is that the argument you're making?
Yes, that it did not comply strictly with the power of sale of the mortgage, which is a requirement for Massachusetts.
Right. Paragraph 20, strict compliance with paragraph 22 is required. And then your argument is because 22 refers to the right to cure, which is described in paragraph 19, that strict compliance with paragraph 19 ought to be required as well.
Well, this case is exactly like the Thompson versus JP Morgan Chase, in which it was heard in the appeals court. And it was subsequently sent to Supreme Court the question so that they can answer the question of whether that's the case or not. And I just wanted my case to be heard, be in, whatever their answer for the Supreme Court is what I would like for myself. I'm sorry, I'm nervous.
Don't be, you're doing a very good job.
Thank you. So because it was exactly the same as Thompson versus JP Morgan Chase, and it's now a question of law, a question that's at the Supreme Court. I feel like if that should be the case for me as well, because as I said, I did not realize, because of the ambiguous language, and that it was potentially deceptive until I read it again.
Right. The argument you're making to us now is one that's on the merits, and we have to first grapple with the res judicata argument, because if that argument that is being made by the bank is correct, then we don't get to reach the merits. So I hear you on the merits. I understand what you're saying about the Thompson case and wanting to wait, but this is really a two-step appeal. And the first step, can we hear it? And the second case is, if we can, what should we do? And we have to go through both of those steps.
I'm sorry, ma'am, I'm just reading my paper, Your Honor. So what about the citation, insurance versus Gomez? Wouldn't res judicata not apply if the language was deceptive and I didn't realize until later?
Well, that's your argument. We're hearing it.
Okay. So also, I believe that had our, well, I don't know if I can even bring that up. Yes, I have another question. The judge and the lower court stated that my opposition was not considered if it wasn't considered, how can res judicata be a part of the ruling in favor of them if it was not considered?
Well, I think what we're trying to get at is even if the judge had considered it, that's to say, even if we agreed with you that it was an abuse of discretion for the judge to have stricken your summary judgment opposition, then what would have happened? If the judge had considered that argument that you made, then what would the correct result on the law have been? And if the correct result would still have been that either your claim was barred by res judicata or that strict compliance with paragraph 19 was not required, then it wouldn't really matter that the judge had stricken your opposition. We're talking about skipping over the question of whether the judge abused his discretion in striking it and trying to look at the actual arguments you made in that opposition and see if they would have helped your case actually.
Right. Can I just have a question. So if he had not stricken it, res judicata should not apply to a post foreclosure that challenges the title or possession. And
well, I think the argument that I hear the bank making is that res judicata applies not because there was a foreclosure, but because you and your husband had filed a case in Essex Superior Court challenging the bank's right to foreclose. And you raised a number of claims as to why the bank didn't have a right to foreclose at that time. And those were all, the court ruled against you on all of those claims. And I think the bank's argument is that was the time, that was your one chance to raise the argument you're trying to raise in this litigation. So it's not based on the foreclosure, but based on the prior lawsuit that you brought against the bank.
Right. So, and as I said before, I was unable to bring up that issue because of the vagueness and the potential deception of the notice. And when I first looked at it at face value, it appears to be correct. And I would not have gone back to it had I not saw that it was highly redacted and I found my disclosure notice. So res judicata, just one more question. One more thing, Yana.
You've got 20 seconds, so you may just want to wrap up.
Well, I just wanted to bring up again that restatement. It says that due to misleading, ambiguous, and potentially deceptive language, an intelligent person would not be able to bring forward the issue of that prior proceeding. And I was not able to because of that.
We understand. Thank you very much.
Thank you.
Mr. Williamson.
Good afternoon, Your Honors. May it please the court. My name is Attorney Williamson. I'm here to represent the appellee in this matter and the plaintiff in the underlying matter, HSBC Bank. I believe based on your back and forth with Ms. Palisio, it's quite clear that there's not an issue being raised whether or not my client made its prima facie showing at the trial court level. It's really a matter if her defenses and arguments and counterclaims in response are enough to prevent judgment from entering. In her answer and counterclaim, she essentially raised only two issues. One, that the assignment was void, and two, that there were 93A violations going back to essentially the origination of the mortgage of 2006 and the acts that went along with it, which would have been the refinance, the discharge of the prior mortgages, etc. With regard to the assignment, I think it's quite clear from the long litigious history of this case that these issues were the exact issues raised in the Essex Superior Court matter, that she particularly put the validity of the assignment at issue at that time. And by raising it again here, it's subject to being barred by the doctrine of res judicata. In her briefing and in her oral arguments just now, nowhere did she cite any sort of precedent that this claim would not be barred in an eviction, a post foreclosure eviction proceedings if she had raised it in a prior, Superior Court matter as she did here. I think it's quite clear when looking at Justice Del Puerto's order that he quite strongly held that this was the exact same claim that was raised before the Essex Superior Court. That being said, the validity of her arguments regarding the assignment or its potential voidness are not true because she does not standing to challenge it. I think there's a a litany of case law out there regarding a mortgagor's ability to challenge the validity of an assignment that they're not a party to. With regard to a 93A claim, which seems to surround the origination and discharge of the prior mortgage and the issuance of this mortgage, that could clearly be time barred by the 4-year statute of limitation, whether she raised the claim in the Superior Court matter if she intended to, or as she did here. That being said, my client was not a party to the origination of that mortgage, nor were they a prior mortgagee of the past mortgage. They were not involved at all. So there is no causation, there's no damages on the part of my client if she actually properly alleged a 93A claim, nor does their role as an assignee assign also any sort of liability or any sort of damages that could have occurred, not that any have been shown. With regard to the Thompson issue, which it seems is the crux of this matter, the appeals court, the First Circuit initially entered its decision on February 8, 2019, whereas the appellants in this matter filed their answer and counterclaims on February 22nd of 2019. In those answers and counterclaims, they did not raise this Thompson issue. Under Rule 12B, essentially they would be waived for proceeding with those. That being said, when they did raise them in their opposition to our motion for summary judgment, which was struck, bringing them forth now at this point, they're essentially bringing them forward for the first time on appeal. I understand that Judge Del Puerto orally heard the argument, so essentially that might not be the case. But at the same time, by orally hearing them, they were insufficient under Rule 56E, since there's no documentation, no affidavit. They're really just bare assertions and conclusions regarding what was seemed like, which they allege was a default notice that had issues. That being said, when looking at the Thompson decision itself, when going back to the order that the First Circuit subsequently issued in July of last year, they strongly noted that because that case made it to the federal circuits on diversity jurisdiction, any decision they entered from that case would not overturn any governing state precedent, meaning that even if the Thompson decision from February of last year was still in place, it wouldn't even be applicable to this matter absent state precedent changing, whether from this court or from the SJC. Furthermore, I think the briefing before Thompson's quite extensive. I know oral arguments were held back in February and the matter is still under advisement as it stands today. But that specific language that was included in the default notice disclosure was required by a mass banking regulation to be included. It was required that that was included. That being said, the language that was in that disclosure actually provides more rights to the borrower. So to say that it's unfair, deceptive, predatory, any sort of language used to attack it, when it actually provides more rights than contractually given under the mortgage, I think that when the SJC ultimately reviews this matter and issues their decision, I think we're likely to see that they will find the same. With regard to the striking of the opposition, I'm not sure how much it's worth going into outside of what's already contained within my briefs, but I think it's quite clear from the record before you that at the time that I opposed the motion to compel, I supplemented the discovery that was sought. And when I'm looking at Judge Del Puerto's order on that, he references that the plaintiff agreed without waiver to supplement responses B and K, which is exactly what I did. I understand
the confusing part of that is that you did it that day. Tell me if I've got the sequence of events right or wrong. You did it that day, but then he issues an order which might suggest to the normal reader that he thought you were going to produce more. Did he issue that order after you'd made your supplemental disclosure?
Yes, Your Honor. What happened was at the same time I drafted and filed my opposition, I also drafted and served the supplemental opposition or supplemental discovery responding to those. We then had a hearing, which was initially scheduled on the motion for summary judgment, the transcripts of which are included in the appendix. At that hearing, we discussed this matter where I basically made the argument that the documents sought by the Palacios were documents that were from Fidelity at the time of origination that my client would not necessarily have unless they transferred over to them at the time of the assignment or servicer change, anything like that.
But after you told the judge, well, I've already supplemented, he still issues this order which suggests that there's going to be more forthcoming.
He did, but I think review of the transcripts will show that I made it quite clear that I supplemented prior to his order. And also looking at the transcripts from our next hearing, I made it clear to him again that I supplemented at the time and offered to enter into the record the supplemental responses that I did, and he didn't find that necessary. So I would.
Okay. I mean, my only point is one can understand why the Palacios might have gotten a bit confused, just given the traffic, the way things played out. But your point is that you made the supplementation and that you believe that the colloquies you had with the judge established that he thought your supplementation was adequate.
Yes, Your Honor. I think if he had an issue with what I supplementary produced, he would have asked to see it to make sure that it complied with his order. I think he based on that he didn't want to see it. He didn't find an issue with it. That being said, at no point, after that, the deadline that was in that order, did I hear from Ms. Palacio saying, hey, where's the discovery? It wasn't until I arrived to the courthouse the morning of the hearing that I was handed this opposition that said I never received anything. And kind of in reviewing that issue and looking back, I went back and looked at the second summary judgment decision from the Essex Superior Court, where the Palacios also were trying to file a 56F opposition. And in that, Judge Healey said, plaintiff's request for continuance and more relevant discovery is simply an attempt by plaintiffs to delay this matter as long as possible, with the benefit to them of their continued occupancy.
Excuse me, Attorney Williamson, is this in our record?
Yes, that is. It is at supplemental appendix page 120. So this is not the first time that a discovery issue has been used to attempt to prolong a decision on a summary judgment. And
was that affidavit given to the motion judge in this appeal, though?
Which affidavit?
Was it the one you're reading from? Excuse me, the order you're reading from. Was that given to the housing court judge?
Yes, that would have been entered into the record because it was the basis of his res judicata decision, seeing order. Let me see. It would have been Exhibit 13 to the motion of summary judgment. So that was in the record at the time, and I'm not sure if he was aware of it at the time he entered the order back in May, but he would have been aware of it after reviewing the summary judgment material and having a hearing on that. So based on that, I think it was properly stricken. We had outlined a pretty clear tracking order, for lack of a better word, of how this was going to be briefed. Instead of sending in an opposition to be filed, they filed the motion to compel. Judge Del Puerto gave him more time. I supplemented. Yet the opposition was not timely filed, despite getting a second chance, and there it was struck. Finally, I'm not sure if it needs to be addressed, but I believe the motion for reconsideration is also on appeal. That document pretty simply just stated that they didn't agree with the decision, and that was their only grounds for seeking reconsideration. They didn't enter any sort of changed circumstance evidence or any sort of error from the court. So based on that there were no grounds to appeal, I would say this court also has grounds to affirm that denial. And unless the court has any other questions, I will rest on my briefing.
Seeing none, well, thank you both. We'll take this under advisement.
Thank you, Your Honors.